Okay, so we have a concept called UB just EB remedium. Okay, so what is UB just EB remedium is basically it talks about rights and duties. Okay, so when we talk about rights and duties are always correlated. If you are being given a right, someone else has to have a duty to ensure you are able to enjoy your rights. Okay, if we say that, okay, we have a right to security. Okay, in that case, state is having a responsibility to ensure that we are safe. And also other people are having a responsibility or a duty to ensure they do not uh, do something which violates our security or safety. Otherwise, it would be considered as a crime. So whenever there is a right, there has to be a duty. Without that, rights are meaningless. So if a right is recognized by state is violated, then the state provides for a remedy also. If state is saying that, okay, fine, you have a right to maybe free and compulsory primary education. In that case, they are not simply saying that you have a right to get free and compulsory primary education. They are also bringing in a legislation imposing obligations on the education department, inspector of schools, on the government schools, their management, their teachers, authorities, on everyone to ensure that yes, kids between 6 to 14 years are able to get free education. Okay, otherwise rights will be meaningless if we do not fix duties on the respective persons. Okay, so what is UB just EB remedium? It means that where there is a right, there is a remedy. Rights will simply not be given to you. Whenever a right is given, a remedy will also be given, because we have this inherent tendency of trying to break the rules or laws. Okay, so, but there are some limitations to this concept, UB just EB remedium. Even though it says that yes, whenever there is a right, there is a remedy, there are certain limitations to it. So what are these limitations? This principle does not apply to moral or political wrong which are not actionable. It just applies to legal wrongs, as in something which is recognized under law. But something which is morally not correct, politically not correct, there it's not applicable. Okay, might be we say that, okay, whoever is in need, we should try to help them. Whoever is hungry, we should try to feed them. Even if I do not feed a hungry person, even though I do not help a person who was in need, nobody can question me, right? There cannot be a legal remedy available because it is not a legal right. It's just a moral obligation which I had, that if I'm able, I should be helping somebody who needs help, right? But even though I'm not doing it, there is no provision or there is no remedy. So that is nothing but a limitation to this concept. It just applies to legal wrongs only, like legal rights only it applies. This is not applicable in those cases in which proper remedy is given in case of breach of right under common law. So this principle would not be applicable where proper remedy is given for breach of right. If your right has been violated, you have a remedy under common law. Common law is something which is not codified, which is not written, but it has developed with time, maybe with case laws it has developed. Okay, there also it would not be applicable because as such remedy would not be given, but we have previous cases that we can refer, that like this, in this case decision came, and like that we can go for it. If there is no legal damage which has been caused to any person, then this maxim will not be applicable. Legal damage is very much important. If you have simply suffered loss, like the case of Gloucester Grammar School, there also this principle would not apply because legal damage is not there. No remedies are available in case of breach of marriage vows or personal commitments, as these are all promises made without consideration and are based on trust. Yes, there are certain remedies or reliefs like alimony, claiming for maintenance, etc. But these are not like, yes, if I'm getting divorced, this is a remedy, not like a hard and fast rule, right? There also a lot of things are taken into consideration before deciding whether person is entitled to maintenance or not. If yes, how much of maintenance the person would get. So there also it's not applicable, because it's like a personal commitment based on trust. Depending on situation, maintenance and other things might be applicable, might not be applicable also. It is also not applicable in case of public nuisance until and unless a plaintiff shows that he suffered more injury than other members of the society. So nuisance as in disturbance, right? If it is a private nuisance, if I am playing loud music, your sleep is disturbed, you can file a case claim for compensation. But what if it is a public nuisance? Entire population has been affected. There you might not be allowed to simply go and file a case, because it's not just you, but this entire population who suffered loss. So entire population should come together and file a case. But yes, if you have suffered more injury than the other people, there you might be allowed to file a case also. This is also a limitation when we say that every right is having a remedy. It is not applicable where plaintiff is negligent or there is negligence on part of plaintiff. Yes, I have suffered a loss, but what happened is I have only contributed there. I was only being negligent. There also it is not applicable. Okay, maybe one of my neighbors is planting some poisonous trees within his closed premises. He has properly fenced it. He has properly locked it also. But what I did is I entered his premises by breaking the lock or something like that. There I cannot say that, okay, my right has been violated. I ate this poisonous trees. Now I'm having health issues. Because it was me who was being negligent. Okay. There also this would not be applicable.
Ma'am, for the last point, like for example, somebody who is crossing the road by looking into their mobile or something like that, in such cases, if some accident happens, so that person who is crossing the road by looking into mobile will not be eligible for any compensation or something like that?
If it is like a minor injury, he is not entitled to compensation because he himself was negligent while crossing the road. Okay, but when we talk about this legislation, right, compensations and all are taken care under Motor Vehicles Act. This is considered to be a social welfare legislation. Okay, as in this legislation is introduced for betterment of the society, betterment of the people, to provide them welfare. Okay, so what happens is we have an exceptional provision there, which is called as no fault liability. As in, it might not be your fault. Okay, might be you were driving or riding a vehicle and I was crossing the road negligently by looking into my mobile or speaking over phone. What happens is no fault liability, even though you were not having any fault, you were driving or riding properly. It was me who was wrong. Even in such a case, this legislation talks about some compensation because it is a social welfare legislation. It tries to think about benefit or welfare of the people in general. Okay, so I will be entitled to compensation, but only in two cases. If there is permanent disablement or if there is death. Okay, otherwise for minor injuries and all, I'm not entitled to compensation because I was negligent. But in these cases, permanent disablement or death, the family would suffer ultimately, right? So we do not see who was liable, who was at fault and stuff like that, but a fixed amount of compensation is being provided. Amount is also fixed here. That amount would be provided.
Okay.
Okay, so these are some of the limitations to this concept. So what are the ingredients that we have? There must be a right which is recognized by law. First of all, there should be a right which is recognized by law. It should not be something which we feel that we have. Like I said, moral rights, feeding the hungry, helping the one who is in need. those are not something which is recognized by law. A person might feel that, okay, I'm hungry, this person is having enough of food, he should be feeding me. I am in need of help, this person is having enough time, he can help me, he should help me. But these rights are not recognized by law. Okay, so we need something which is recognized by law. Secondly, violation of such right which caused damage or loss or injury. Whatever right was recognized by law, that right was being violated. As a result, it has caused damage. When we say damage, it might not be damage in terms of comfort, health, money, reputation that we can show before the court, but the right is being violated. That is important. Okay. The main remedy should be for damages. When the right is being violated, the person claims for damages, right? The person claims for compensation. The nature of act varies from situation to situation. What was the violation? What was the right all about? How was it violated? What remedy is available? That might vary. Okay, even if you talk about civil wrongs, there are different types of remedies available in civil wrong. So like that, there may be variation in terms of the remedy available depending on the situation or depending on the kind of right that is available. But these are the ingredients. Right, when we talk about right, it should be something which is recognized under law. It is being violated, we have a remedy available, but the other remedy might vary. The kind of violation of right may vary, how it was violated may vary, but that is all okay. Okay, now there are certain cases relating to this UBJ-CB remedium, that a right was being given, that right was being violated, we had remedy available, the person filed the case and he got remedy. Okay, first one is SB versus White. We discussed this case previously also in those maxims, right? So SB versus White relating to right to vote. Right to vote was a right which was given to him. That right was being violated by the presiding officer, and what happened is he was considered entitled for compensation, even though in reality there was no actual harm or loss suffered by him because the candidate anyways won the election. But still, because his right was being violated, he was considered entitled for compensation. Same ways, another case is there which I mentioned that time, Bhim Singh MLA versus State of Jammu and Kashmir, wherein MLA of Jammu and Kashmir, Bhim Singh was MLA of Jammu and Kashmir parliamentary gathering, and while he was on the route to go to the parliamentary meeting, he was improperly captured, as in there was no valid reason or ground for arresting him, but he was improperly captured by cop and was controlled from going to the parliamentary meeting. He was restricted from going to the parliamentary meeting even though he was qualified to go there. He was not introduced before the judge on time, and he had a lawful right to go to the gathering. When a person is arrested, within 24 hours, he should be produced before the magistrate. But that thing also did not happen. He was simply arrested. He was not produced before the judge also because there was no valid reason for his arrest. What justification would they give before the judge, right? He was not produced before the judge. And his fundamental right under Article 21 of Constitution, that is right to life and personal liberty, that right was being violated, right? He was not given personal liberty to go and attend the assembly session. In this case, Supreme Court considered that his right was being violated and he was considered entitled to compensation of 50,000 rupees. So this is also nothing but a right has been given. That right was being violated improperly. Remedy was available. The person approached the court and he did get the remedy or relief as well. Okay, another one is there. Verity versus Williams. The defendant was owner of a bank and plaintiff had an account in the same bank. Plaintiff had sufficient funds in his account when plaintiff went to the bank to honor a check. Now, what is sufficient funds in the account, that the banker cannot decide, right? Because that would vary from person to person. And also, even though a person is having sufficient funds in his account, if he deposits a check, he has all the rights to get it cleared, to get it honored, if there is no other issues with the check. Okay. But in this case, what happened is he deposited a check, but defendant refused to honor the check to him. This owner of the bank, he refused to honor the check to him because he was having sufficient funds in his account. The court held that the defendant is liable for the loss caused to plaintiff. The court applied the principle ubi jus ibi remedium. As the plaintiff's legal right was violated, defendant was held liable to pay. So once you have a bank account, once you produce a valid check, if there are no other issues, the bank should clear the check. If they are not doing it, as in they are violating your legal right, there also the person was considered entitled to receive compensation. Okay, and last one we have, this is a very famous case you will get in constitution also and other subjects as well. Okay, so it is D.K. Basu versus State of West Bengal. This is a public interest litigation. Okay, D.K. Basu filed the case, but he was not the victim or he was not suffering anything. He just filed the case as public interest litigation. So what happened here is D.K. Basu was working as executive chairman in Legal Aid Services West Bengal, which is a non-political organization, and he was working there. Now what happened is he realized that there was this problem of custodial violence. Okay, and he read it in many newspapers. So what he did is he wrote a letter to the Chief Justice of India telling him about certain news articles which were published in Indian Express and Telegraph regarding death of a person in police lockup and custody. That this problem is there, custodial violence is there, and there was this death of this person, and court should take up the matter, or court should do something about it. He wrote a letter like that. So Chief Justice of India also wrote the letter, and he can, felt that yes, this was an important matter, and he converted it into a public interest litigation. After hearing this case, Supreme Court issued 11 guidelines. Okay, 11 guidelines which needed to be followed during arrest of the accused person. When we say accused person, his guilt is not yet proved, right? Somebody is accusing that he has committed a wrong. So even though we are arresting a person, there are certain rights which are available to the accused person. Just because he is accused of committing a crime, we cannot treat him in a very bad way. Okay, so there were 11 guidelines which were issued that even though person is accused of committing a crime, this should be followed. All right, these guidelines were like, when a police officer goes to arrest him, he should wear proper uniform. His name and designation should be visible. He should let the accused person know the grounds for his arrest. He should allow the accused person to make at least one phone call to inform his friends or family that I'm being arrested, so that they can arrange a lawyer and stuff like that. Okay, so there are 11 guidelines which were issued that even though a person is accused of committing a crime, he is having some rights, and those rights should be respected by the police officers while the person is being arrested. Okay, is this part clear, cases?
Yes.
So these 4 cases we have, which are again first 2, right? First 2 are something that you can mention there also, like first 3 only you can mention in those maxims as well. So the law provides and makes sure that people do not suffer from violations of their rights. It's not that only rights would be provided and then law would not take any action whether it's violated or not. It is not like that. It ensures proper damages and compensation are provided to them by invoking the maxim UB just EB remedium. Depending on the type of right available, different types of remedies are also provided so that the person can get the type of damages which is like best in that given situation. However, a person gets the remedy when his legal right has been infringed. It is not applicable for violation of moral rights. If there is infringement of a person's legal right, then defendant will be held liable to pay the amount of damages as compensation. This maxim is commonly evident as no right exists without a remedy. So you cannot simply say that this right is there, but there is no remedy, because otherwise it would make no sense. So whenever you see a right given under a certain legislation, remedy will also be provided. Okay, so this is UB just EB remedium. This is also an important concept. Many times they ask questions. What is the concept of UB just EB remedium? Explain with the help of cases. There you can mention it.